let me get to Malik Kweko Baako, because he has also, using some documents and information that have come to him, made certain commentary, and you know, people are faulting his point of view and so on and so forth. Yes, so like the last point Abochi mentioned, for lawyers, I'll be frank with you, we normally say, I prefer my client to be granted bail by the court. I don't want a police bail, because police will harass you every day. They'll say, come this morning, come tomorrow. They can call you anytime. But when the court grants your client bail, you can be sure that nobody else will call them to come any other place except when the court needs them. And that is determined in advance. Your reading of the documents available to you suggests a different position, or you have a revised position?
Oh, no.
Okay.
I'm consistent relative to my understanding of the documents I read and the public discussions that have gone on. And I'm going to sustain that position. See, there's no dispute that the court granted bail to Mr. Afoko, 14th March 2019. There's no dispute about that.
Okay.
And as Jose referred to, a letter 23rd April 2019 from Deputy Registrar of the Court, Mr. Frank Broby, addressed to the CID Director General, asking that Afoko should be brought to the court for the bail bond to be executed.
Right.
This is 23rd of April 2019. Subsequent to this letter, there's another one dated 3rd May 2019 from the same High Court, this time forwarding to the police. Would respectfully forward here with a certified true copy of the reply from the Lands Commission, Land Registration Division, on a search conducted at the Lands Commission, an evaluation report received from the Architecture and Engineering Services Limited on a valuation request from the Registrar of the Court for your information and necessary action. So it means that subsequent to the 23rd April letter, the High Court now forwards to the police that research that they had done, which is dated 3rd May. So I'm not too sure that the 23rd April letter by itself was sufficient. Otherwise, this 3rd May letter now sending the substance in terms of the search the registrar has done to the police.
So the suggestion reasonably would be that after they sent and they didn't comply with that, they may have asked them, can you prove why you say you are satisfied?
Yeah.
So they forward the documents
to them.
Okay.
And then, of course, there's an earlier letter dated 28th March 2019 from the Lands Commission to the High Court. It has referred to that in terms of the search that the court, the registrar had done. Now, I've been doing some few searches. I've listened to the two lawyers here, and especially Mr. Abuti, who you know I defer a lot to. But today, I think we'll have a point of departure. See, that issue has been raised here and answered by Mr. Abuti in the positive towards your question. Who really does the verification and authentication, validation of a surety? Who does that? I've heard the lawyer say it's the court, it's within the preserve of the court. So it means it's the court registrar. Okay, let me read this thing, and then since you are good, this is the second edition of the Criminal Procedure and Practice in Ghana by Dennis Dominic Ajay.
Right.
I'm sure you may have followed.
That's it. That's the book I'm just showing you.
Okay. There is this page 177, the second paragraph. It says, at times, it becomes a tug of war between the registrar of the court which granted bail to an accused person, and the police investigator in the case as to who has the duty to ascertain the background and competence of the sureties. Police Service Instructions 177, Part 2, provides that where bail is granted by the court, it is the duty of the prosecutor responsible for the case or the investigator responsible for the case to ascertain the identity and the competence of the surety provided by the accused. The prosecutor or the investigator should ascertain whether the surety has a fixed place of abode, whether that surety is a person of substance and not a professional surety. The police investigator or the prosecutor who investigated the background of the surety should report his or her findings to the court for the court to decide whether the person can stand as a surety. A police prosecutor or the investigator whose investigations proves that the surety is a person of substance and fit to stand surety for the accused in the case has the burden to entreat the bond against the surety in a case where the accused absconds. The background checks of a potential surety should be made by the investigator or the prosecutor responsible for the case and not an officer of the court. An officer of the court who supervises the execution of a bond shall get a report from the investigator or the prosecutor before she permits the person to stand as surety. Where the police investigator or the prosecutor is opposed to the grant of a bail and the court grants it in spite of the position, and that officer fails to cooperate with the court to investigate the background of the proposed surety or decides to frustrate the proposed surety so that the accused will be taken to custody, the conduct of that police officer shall be reported to the presiding judge forthwith. The judge may deal with the police officer by ordering him or her to comply with the order made by the court, or may by order report the conduct of the police officer to his or superiors.
Okay.
Absolutely.
My point is this: the search, the authentication, the validation of the surety, as indicated here, is the job of the investigator or the prosecutor. Is that in dispute?
A little bit.
Yeah,
little
I don't know. This is a. As you are holding a copy,
yes.
It means it has value.
Sir Dennis J is a very respected judge, a respectable judge,
judges.
and his positions are very strong. But let me, with the greatest respect.
I haven't finished.
Very well.
But because my trust is on that aspect.
At least you are fortified.
That yes, that if the court registrar on its own conducted this particular investigation, this instance case, and then comes to the court to tell the court that yes, I have finished, so ask the police to come and bring the gentleman for the bond to be executed. Are we suggesting that the police ought not to do validation of what it has been told? Assuming, and this is just hypothetical, I'm not saying Mr. Afoko would have absconded, but assuming bail granted, there's an element of flight risk. He's been in custody for 4 years anyway. He's facing trial finally, at the final almost stage is terminated for retrial. One other person who was accused escaped earlier, was brought back after 4 years. Are we saying that the police ought not to subject what the court registrar has done to validation and verification, to be sure that indeed this surety would stand, assuming in the unlikely situation, I'm going to be charitable, the accused person absconds? When the accused absconds, who is responsible for locating, searching, and apprehending?
Is the prosecution.
Thank you.
The police.
So it's the police.
If they have to extreat the bond, is the prosecution.
That is why I think in practice, and I've been educated on it too, that in practice, there ought to be close collaboration between the registrar and the police.
Okay.
Relative to such a thing. When a gap occurs, some of these problems we are having could occur.
Okay.
Now here's a situation where the police, the court registrar says, oh, the gentleman brought, the surety brought the original. They made copies and sent the copy Okay, my brother was referring to June 11th, judgment by the judge.
Order.
The order. Fortunately for me, I was able to assess.
If you want to read that, my copy is here if you can't find it. Okay, go ahead.
No, I'm talking of the record of proceedings.
Okay, record of proceedings, yeah.
Because the order is here. I also have a copy. See, and again, allow me to go through it because I'm going to make my point on that.
You have time to do that.
This is the order of proceedings dated June 11th, 2019. Chief State Attorney speaking. So we requested for the authentication of the land certificate. We will need an affirmation of the genuineness of the land certificate. We received a response indicating that the land is duly registered in the name of, he didn't want to mention the name, but this is a public record.
Now the name has been mentioned over again.
Yes, George Hika Benson, the name on the land certificate. However, the Lands Commission has indicated in their response that the authenticity or otherwise of the land certificate can only be determined if the original land certificate is produced by the respondent. They have advised that the original land certificate be provided. Consequently, the respondents have written to the said Hika Benson, who has received the letter from the respondents and has indicated that he will make available the land certificate.
Who is speaking?
This is the state attorney.
Right.
Chief State Attorney.
Right.
To the respondents. As soon as we receive this, it will be sent to the Lands Commission for the authentication process. We are therefore praying for a few days for all this to be done. Then the counsel for the applicant, in this case, Afoko, comes in. I am not sure about the said Mr. Benson's readiness to furnish the police with the original title certificate. I wonder why. What's so difficult about that?
In fact, they wrote to them, except that they are saying the police received and returned their DHL letter,
that make sense to you?
And that they actually told the police to their face that they will not give it to them.
Does it make sense to you?
Okay, go ahead.
That you DHL something to a police station. You say the letter was not opened but brought back. Brought back by whom?
Okay,
who received it and refused to accept it? Give us those details. So I'm not putting much premium on that.
Okay.
They claimed they had written to the police. That's why somebody told me, in fact, somebody very close to Mr. Benson. But it subsequently turned out a letter written by one of Afoko's lawyers.
Yes.
He's now saying that the thing was sent by DHL and was returned, but it was unopened. But in any case, the letter was not sent to the lawyers. It was sent to Mr. Benson. And according to the police, he agreed he would sign it, even though here, you can see it from here. But let me continue.
It's important he goes through the record.
I'm going through it.
Go ahead,
yes,
go ahead.
I'm going through it because of something you said. It says, Dr. Benson feels harassed by the police. One of the administrative requirements for the execution of the bail bond is for the surety to furnish the court with the original copy of the document. The original title certificate was submitted to the registry, who dispatched a bailiff to the Lands Commission to conduct the search. Note here carefully. The court then comes in. This is by court. Let Mr. Frank Broby, the registrar who wrote the letter, be summoned to court. Mr. Broby is in court. To Mr. Broby, did you write this letter dated 23rd April 2019 to the Director General of CID? Letter we've all referred to. Yes, my lord. What necessitated the said letter asking that the accused be brought to the registry for the bail bond to be executed? The Lands Commission wrote in a letter, then he was stopped there. Do you have a copy of that letter? Yes, I can produce it. Stood down for the letter to be produced. Question: what is the procedure when bail is granted with justification? When bail is granted with justification, we ask the sureties to bring us a landed property so we take the original and make photocopies. We then send the copy to the Lands Commission. I didn't hear him say they send the original. They send the photocopy to the Lands Commission. We ask about the genuineness of the property, whether the land has been registered. The commission will write to us in respect of the property, whether or not it is duly registered. if properly registered, will write to the police or whoever is in charge for the bail to be executed. So when you write to the police as whoever is in charge, it means the bail conditions have been satisfied. His answer, that is so. By court, on 25th March 2019, the registrar of the court wrote to the Director Land Registration Division requesting for a search. It states as follows: request for a search between Ne Ayi Anan and George Hika Benson. I forward here with photocopy of land document submitted to this registry, photocopy, mark it, to this registry in relation to a matter pending before the court. The court would like to know the current status of the property with registration number so-and-so 180/14/649/1. Please acknowledge receipt. On 28th March 2019, the Director of Lands Registration Division wrote in response to the registrar's letter as follows: request for search. Reference your letter number so-and-so dated 25th March 2019 for a search on land situated at Kwabenya. Copy of this site attached for ease of reference. Case of reference, that's what it's here.
Ease of reference, that's it.
But it's a typo.
Yeah, I think it's a typo.
We wish to inform you that the whole site is affected by land certificate number so-and-so and so issued to Mr. George Hika Benson. This letter is with registration number so-and-so and so. On 23rd April, the registrar addressed a letter to the Director General of Ghana Police CID, suit number so-and-so. Respectfully, the accused person herein has been granted bail by this honorable court. Kindly bring him to this registry for the bail bond to be executed. That is the 23rd letter.
Yes. Right.
Thanks for your cooperation in this regard. All these correspondence were in respect of bail granted to the accused person on 14th March 2019 before the High Court, differently constituted. The High Court delivered itself thus in its punctuated paragraph. I quote, again, I'm not sure if there's a typo here. It says, I have no legislation. I'm sure it maybe said I have no hesitation.
Yeah, you should
I suspect. I have no legislation.
Hesitation.
I suspect
yeah,
this, but it's stated here as legislation.
Yeah, hesitation.
I have no legislation under the circumstances of, I have no hesitation, let's do the correction, under the circumstances of this case to grant the application and to commit the applicant to bail in sum of 500,000 cedis with two sureties, one of whom is to provide justification. In addition, the court directs the accused applicant to report himself every day, fortnight, to the CID Ghana Police at headquarters, ordered accordingly. I mean,
every 2 weeks.
Every 2 weeks.
Okay.
Now, the difficulty I've had is that, and it's because I'm doing a certain search. Right now, there are about 10 cases in court 1 that have been struck out, dead. Why? Because of similar things like this. The court registrars, and some of the investigators bring documents that they claim have been certified by Lands Commission. Most of these cases are robbery cases. Few are fraud and forgery.
That's why Justice Dennis Ejay referred to professional bail. They call them bail contractors. Bail contractors.
This has been done.
Right.
And because due diligence was not conducted, and the court accepted those documents on their face value based on what the registrar is saying, those accused persons or suspects have absconded.
Okay.
The sureties have also gone into hiding. And those documents, some have turned out to be fake. This is a phenomenon happening in our courts, and I'm sure you know about it.
Okay, so can I ask you just a couple of questions?
No, let me finish. That is why I thought further due diligence based on what the court registrar has said was proper.
Okay, so
and reinforced by what Dennis Ajay is saying here.
That there is often a tug of war between the registrar and the police.
The best solution is for them to collaborate.
Right.
If they won't collaborate, then the registrar on his own should not be given space to conduct those searches.
So on the basis of the need for collaboration, it appears the police doubts the registrar. Is that your understanding?
Well, I don't speak for the police, but you see,
let's speak to the evidence as we have it now.
Yeah.
On the basis of question of collaboration between the two, it appears the police doubt the registrar because
relative to the absence of the original.
Yes.
Good.
Because when they wrote, and when the registrar wrote and asked that they should bring the person, they didn't. And then further, you have just giving us the evidence where they now provided the documentation that they had done, the searches. And the search is the question of the ownership of the property in doubt.
No.
Has Land Commission raised any doubt about the ownership?
No, by the effect of their letter, no.
Okay.
But you see, I asked you a very important point. I made a point that, for instance, assuming the accused person absconds, who executes prosecution, and if it turns out that subsequent to what Lands Commission has said, the person holding the original, because they haven't kept the original even by this thing, there's the impression that they say they kept the original, but no, the original went back to the owner. That's why the police were asking the owner to bring it. And the letter written by one of Afoko's own lawyers makes the point that there was no need for them to give the original.
Okay, so let me just exhaust my two questions.
The point I'm making, no, let me finish.
As for the original going back, I think it's a normal thing. You take the original, do what you want with it, and give it back to the owner.
Yes, so when now the police were doing due diligence, say extra, I believe they were right to do so because of the records happening in the courts.
All right.
People absconding.
Do you also say that when the court made an unequivocal order for the bail bond to be executed, that the police have a right to say a court has made an order, but because we have some doubts with a certain registrar's process, we ignore the court's order?
Well, the police didn't say that directly. If you read the record, they didn't say that directly.
Yes, sure.
They didn't. The records of proceedings show that, and then don't forget, another high court, that is high court differently constituted, had also asked the court registrar, this time a different affidavit, to write to the Lands Commission to hasten procedures in bringing the answer to what the police have said. So technically at that point in time, police also were working within the remit.
That's not the answer to my question.
No, I'm coming. I will answer it. I'm saying that the high court had asked the Lands Commission to hasten procedures and produce the answer the police were asking for.
Yeah, the same judge in the commercial court, Jennifer Dodo, right?
Yes.
So Afote is in charge of commercial courts.
And what the lawyer, Afoko's lawyers are saying is that she was then unaware of the previous situation in the other high court.
So if you may just answer my question quickly, and then I come to Doc. Question is, a court gives an order. Police produce this person and let him execute a bail bond. They don't do it. Can we say that they have a right to do so? They can do so?
Well, you know what? I will err on the side of the police in this case. Because if they do that, and in the unlikely situation, and as I'm being charitable, the accused absconds, will come and sit here and deal with the police.
Okay, thank you. So,
but Samson.
No, hold on.
Samson, you see, it's important that certain things are situated well. Just 1 minute, please. Then the doc can just come. Just 1 minute. Look, you see, Mr. Baako makes the point, and he reads the records of proceedings. The difficulty the police had, which Mr. Baako articulates, that they want to establish whether the documents were authentic.
And how difficult was it for the court to cooperate, the registrar to cooperate?
So when that matter came up, and Chief Inspector Nkrumah raised that issue before Jennifer Dodo, she quickly called Mr. Afote. So when she made the order,
that Mr. Afote or Mr. Broby.
Sorry, Mr. Broby, sorry.
Yeah.
Okay. Who had done it based on...
That's what I've read.
Based on Michael Buedi's decision. Yeah. At that point, she became satisfied that the request by the police to do further authentication of those documents was unfounded. And in fact, indicated that by so doing, they were seeking to frustrate the process of executing the bill.
Okay.
So,
I think the process was defective.
Okay.
No, see, you are expressing the judge's view, and I admit that is the record.
Okay, so
but I sit here and I'm telling you that the processes were defective.
Okay, so there's a reason, that's why particularly for the two of you, there's a reason I gave you so much time. And check the clock where we are now.